The trial of Scot Peterson, the Douglas High officer who did not go in, is a window into how different the rules are between the court of public opinion and the court of law. We saw a preview of that a few months ago on this program when a veteran prosecutor previewed this case, actually arguing for the defense. That veteran prosecutor is back with us today. Gail Levine right there on Zoom with us. Gail, great to have you back.
Thanks, Jenna. Thanks for having me this morning.
So I went and looked at our interview from a couple of months ago, and you said a law enforcement officer is not typically considered a caregiver. You set up that hill that prosecutors were trying to climb. You ended up being spot on. Take us through that.
Well, I think I was spot on because I really didn't just think about the court of public opinion or the court of law. I looked at all of the facts, and that's what the jury was supposed to do. So before I get even further, let me just say this. As a prosecutor that handled mostly murder cases, victim family of violent crime never, ever recover. And my heart goes out to every victim of violent crime, and particularly in this case, to those victims at Marjory Stoneman Douglas and their families. Now, the problem with their thoughts and emotional thoughts of other teachers or people in the community is that those people are not looking objectively at what a law enforcement officer is required to do. So when the jury received the facts, the evidence, and the law, they were able to decipher not what people like emotionally, not what they want to happen, but what did and should happen. So that's what I tried to do a couple of weeks back when I did some research and I tried to figure out what an officer's responsibility was. I think that the state attorney's office really failed to do that. And I was disappointed that they went forward with that prosecution because in a way it makes prosecutors look vengeful. And they were trying to do their job. I'm not saying that any of those prosecutors themselves were vengeful, but I'm saying that the public doesn't get the full flavor. They didn't have maybe the opportunity like I did to watch live stream and watch the testimony and to really see everything that the jury heard. And that's the problem.
Yeah, and really that speaks to every single criminal case that's in every single court, because having had jury experience, the jury sometimes does not know what the public knows because it's not brought in as evidence. But I want to ask you this, to your point. So Scot Peterson had active shooter training as part of his training at Broward Sheriff's. There was, during the trial, one of the trainers came in to testify that he was trained to go in. That was his training, that was the testimony. He did not go in. The charge was as a caretaker. Do you see another statute, another way to levy a charge against a law enforcement officer who does not do what he or she is trained to do?
So I don't think, and I take issue with, I guess, what that trainer said, because really what the trainer left out was, what did the training say? It didn't say drop everything and run towards something you don't know what is going on. It said, if that was the training, everybody would just run to sounds.
Confront the shooter. He was trained to confront the shooter.
But he had to know where he was. And he didn't have any sense of that. Neither did anyone else around him.
Well, so let me just what we know is that there was at least one security guard who watched the shooter go into the 1200 building. 2 security guards took Peterson in their golf cart to the building. And eventually, Coral Springs officers ran into the building. So there was evidence that refutes that, although did the jury hear that? That I don't know.
Yeah, and also, you're also taking pieces of video and putting them together, but are you really looking at them in a timeline, or are you looking at them as a Monday morning quarterback? And I'm not saying you, Glenna, I'm saying the public. You have to see what it was in real time. I've heard some conversation that said, oh, you know, if he just ran in, somebody could have been able to close the door. Shoulda, woulda, coulda. He had to know where the shooter was coming from. And the one thing that I think is really important is we keep using the word accountability. And everybody throws around Scot Peterson's name, but nobody wants to name the person who's accountable. And it's Nicholas Cruz. I said it.
Well,
And
I think that's
maybe,
been, we've been talking, you know, we've been reporting for 5 years about the shooter
sure,
who's responsible. Most
sure.
definitely.
But at this point, it seems like he could have single-handedly taken him down. And that just isn't real. He's not Superman.
So
He
is
was
this,
trained to go in at a certain time. Broward Sheriff's Department had a terrible radio system. Coral Springs was receiving the 911 calls. They knew where the kids were. They knew where the teachers were. There was no connection between the two of them. So if you looked at everything in time as to what he knew and what he saw, you come up probably with the same evidence and the same verdict as that jury.
so it sounds like he himself and really investigations and reporting do raise questions about who knew what when. So the standard is reasonable doubt. So you're saying that all of these things, or any one of them, could raise that reasonable doubt standard that would not allow the jury to fill out those forms in any other way?
Well, I don't believe that the testimony or the evidence rose to the level that he was guilty beyond a reasonable doubt. That's the standard, beyond a reasonable doubt. And he was not. They found that he wasn't. Now, civilly, was there problems? Yes. I don't practice civil law. I know a little bit about it, but you only need about 51% to say somebody was wrong. Beyond a reasonable doubt is an abiding conviction of guilt. That is where your belief doesn't waver or vacillate, that you know exactly what you're determining. It's a very, very high standard. So could Broward County Schools, could the Broward Sheriff's Department been responsible civilly? Probably likely. Do remember, though, they have sovereign immunity and, you know, they're capped at $200,000. So, I mean, civil really wasn't going to get them where they needed to be. You know, they wanted something to hang their hat on, and unfortunately it just wasn't going to be Scot Peterson when you have that many people failing at that level.
Should Peterson have taken the stand at all in his own defense?
That's a very personal decision that a defendant spends a lot of time with their counsel. I think that Mr. Peterson was an emotional guy, and I don't know, maybe they took into account that his emotions could have gotten the best of him and he couldn't have followed the questions because he was so upset. You saw him when the reading of the verdict, he was hysterical. I've watched first-degree murderers accept verdicts and not shed a tear. I've watched people be found not guilty, not shed a tear. This man was overcome with emotion.
Yeah.
It was painful. So I think that maybe he and his counsel felt, listen, the state just does not have proof beyond a reasonable doubt that he was responsible and that he was a caregiver. Food, clothing, all of that stuff, shelter, that's what a caregiver does. And that's not what we want our police to do. Otherwise, like I said before, they just walk into our house without a search warrant, and nobody wants that.
What is so interesting talking to you about this case is I feel like I'm talking to, you know, the prosecutor for the defense, which is a really nice objective view for everybody. Gail Levine, thanks so much. Appreciate you
Thank
hustling
you.
to be with us today.
You're welcome anytime.
Bye.